Hi students, we have already completed with corporate criminal liability in India, the legislation portion. Now we will be coming to the regulatory portions where we will be talking about the regulatory bodies which try to curb this kind of crime, which is the corporate criminal liability or the corporate scams, which is part 2 of chapter 4. So let's see what are the contents in this particular slide, which is listed in slide number 2. We will be talking about NCLT, the CBI, which is Central Bureau of Investigation, the SEBI, Securities and Exchange Board of India. We had previously talked about SEBI, the laws, what are the powers and functions of SEBI. Now we will be talking it as a regulatory body. Then we have the Enforcement Directorate, which basically handles the money laundering cases and all. It also has jurisdiction over other corporate scams. Now, let us talk about NCLT and NCLT, which is in slide 3 of our PPT currently. NCLT replaced Company Law Board from June 2016. Please keep this point in mind, because even today, people refer, or even professors I have seen, I have experienced, I have heard from my students that they refer to cases and they still refer to CLB as the adjudicating body for company law cases. It is not correct. NCLT, that is the National Company Law Tribunal, is currently the body wherein all the company law related cases are being referred to. The NCLT or court is a semi-legal authority established under the Companies Act 2013 to deal with what? To deal with corporate civil disputes. Mind you, corporate civil disputes emerging under the Act. It has powers and procedures like those vested in a court of law judge, because of course it's a quasi-legal body, so it will have the same kind of power. The tribunal is not bound by strict judicial rules of evidence and procedure. It can decide cases by following the principles of natural justice. Now, when we talk about the principles of natural justice, we know there are three kind of components or principles that are there, like odi alteram partem, which means both sides should be heard. Nemo judex in causa sua, again rule against bias, and also reasoned decisions, like when when the judges come to a decision, there should be a proper reason. Now, this is the main principles of natural justice, but in simple language we can say where there are no rules and regulations or an act governing a particular particular work or particular anything. In that case, whatever is just for the situation, that can be accommodated. So when we talk about we have completed talking about NCLT. Again, in the previous the other legislation portion, we have referred to NCLT quite a number of times. In the succeeding slides also we will be going through it. Let's see what is NCLT. NCLT is nothing but the appellate tribunal, like the National Company Law Appellate Tribunal, which is an authority provided for dealing with appeals arising out of the decisions of the tribunal. The tribunal here being NCLT. It is formed for correcting the errors made by the NCLT. Now, NCLT is an immediate appellate forum where appeals lie after order of the tribunal or the NCLT. The decisions of the appellate tribunal can further be challenged in the Supreme Court. So, you can see the hierarchy now. So, in the lower level we have NCLT, then NCLT, and then what do we have? Supreme Court, like the apex court. The appellate tribunal reviews the decisions of the tribunal and has power to set aside them or modify or confirm it. So this is just how every appellate body and the kind of powers they have. So let us now go to the basic difference between NCLT and NCLT. Please be very clear, because you might get sometimes confused about this, and in a lot of competitive exams again this difference is asked in the form of MCQs and everything. So NCLT has primary jurisdiction, NCLT has appellate jurisdiction. NCLT is like the lower forum than NCLT, and of course the NCLT is the higher forum. NCLT evidence and witnesses are generally presented here for taking the decisions, but in case of NCLT, generally reviews the decisions of NCLT and checks it on a point of law or fact. Okay, and NCLT fact finding and evidence collection is the primary task of this kind of tribunal. But when we talk about NCLT, they decide cases based on already collected evidence and witnesses. So this is the basic difference that we have in slide 4. In slide 5, we'll be talking about the background of NCLT, because in the subsequent slides, we'll be talking about the past. So before going to the past, we need to talk about the body. And NCLT had been for the first time referred in the old act, but it was always subjected to challenges that it was unconstitutional. So you need to know this. Also, it was for the first time conceptualized by Iradi Committee. Just remember the committee's name. This was Iradi Committee. It was initially introduced in Companies Act 1956 in 2002, but provisions of the Companies Second Amendment Act 2002 were never notified, as they got caught up in litigation surrounding constitutionality of NCLT. 2013 Act was enacted and the concept of NCLT was retained. Okay. Now, the constitutionality of NCLT related provisions were again challenged in the famous case of Madras Bar Association versus Union of India. The citation is 2015 SCC Online SC 1094. And this case was finally decided in May 2015. The Apex Court upheld the constitutionality of the concept of NCLT, but some of the provisions on constitutional selection process were found defective and unconstitutional. In slide 6, we come to the pass of NCLT in relation to corporate frauds. Because I will be particularly referring to only the pass in reference to the corporate frauds, because the other need not be dealt in the CCL course. And also here there is not much of an explanation, because in the module I have referred all this in detailed way. Here I will be just reading out the slides, which I think I have explained with a lot of giving the details of it in the slides. So the first part is class action. So protection of interest of different stakeholders, particularly the non-promoters, shareholders and depositors, has been the concern of company law from a long time. So this was also there in the objective portion, if you remember when we talked about the company law as a legislation. A class action is a procedural device. It is a procedural device that grants at least one or more plaintiffs to file and prosecute a lawsuit in the interest of a bigger gathering or class, like one shareholder can promote the interests of other shareholder, that kind of a thing. It is an idea of a representative suit where the interests of a class is represented by a couple of them, where an enormous number of shareholders, depositors are affected by the fraud. So which is the section regarding this class action we need to know? So section 245 of company law has been introduced in the new company law, that is 2013, to give help to the investors against a large set of wrongful activities committed by the company's management or different consultants and advisors who are related with the organization. So these are key managerial persons that they are talking about mostly. So class action can be filed against the organizations regardless of whether in the public sector or it is in the private sector. It can be filed against any organization which is incorporated under the Companies Act 2013 or any past Companies Act, that is the 1956 or the acts before that. The Act does a single exception. Only one exception is there where class action suit cannot be filed. That is the banking companies. Now, when we go to slide number 7, it talks about deregistration of companies. So the tribunal is enabled to make a few strides, including cancellation of enlistment and dissolving the organization. If you remember the previous classes we did where we talked about like China being one of the companies which take strict actions against cancellation of business licenses when there is a corporate fraud. So again, in the company law also we have a provision wherein deregistration of companies can be initiated by NCLT in case of a fraud or in case of a operational mismanagement. So the tribunal can even proclaim the liability of individuals to be unlimited. The one who is running the companies here, they are being referred to. Section 7, subsection 7 of the Companies Act 2013 gives the new way for deregistration of organization in specific conditions when the registration of organization is obtained in a unlawful or a wrongful way. So I think deregistration of companies, now you are clear with the concept and the powers that NCLT has when there is a unlawful or a wrongful way when the registration has been taken or the business is running for an illegal act and all that. So the next part is operation and mismanagement. The tribunal under section 241 grants any member permission to find justice for past and present instances of operation and mismanagement, thus setting forth remedies for any member or ex-member of a company or central government subjected to the crime under scrutiny. So they can give a permission to any member, that is they being NCLT can give permission to any member to look into this kind of operation and mismanagement and bring out the ones who should be made liable for this. A member can file an application to the tribunal upon the grounds that the affairs of the company are run in a way prejudicial to the public interest, or prejudicial and oppressive towards members of the company, or prejudicial to the very interest of the company. So you can see in this way also the NCLT gives powers to any member to make a complaint when these are the things that are or the right of a member is being affected, or the company is not keeping public interest in mind and causing the members or shareholders a lot of problems. So in that case, any one member can make an application to NCLT and ask for its jurisdiction over the matter. So we are in slide 8 now, where we'll be talking about deposits part and the powers of NCLT over it. So chapter 5 of the 2013 Act and Companies Acceptance of Deposit Rules 2014 deals with deposits and defines the regulations of deposits. Deposit rules provide aggrieved depositors with the remedy of class action, which we had talked about previously, so that they can seek justice for the omissions of the companies which hurt their depositor rights. Also, there is reopening of accounts and revisions of financial statements here. So section 130 and 131 read along with section 447 and 448, which we had previously dealt in the legislation part, remember? So in the new act, that is Companies Act 2013, is a measure taken against this menace. The sections act as provisions to refrain companies from suo motu opening their accounts and revising their financial statements. Section 130 gives the tribunal power to hold the authority to direct a company to reopen its accounts under certain given circumstances, when the tribunal finds that there is a operation or something is going wrong. The company can revise its financial statements under section 131, but not allowed the reopening of any accounts, so that they can cause a manipulation in their financial statements. In slide number 9, we have refusal to transfer of shares. When a company refuses to transfer shares from one member to another, what happens then? So under section 58 and 59, if a company refuses to register, transfer or does any malpractices leading to dissatisfactory of the transferor or transferee, the latter, that is the transferee, is entitled to appeal to the National Company Law Tribunal, that is NCLT, after a period of 2 months. So 2 months they will give time to the company so that they can, go for the transfer of share proceedings. And if once it is the transferee is seeing that nothing is happening, then after 2 months it can make an application to the NCLT that the company is doing some malpractice so as not to register the transfer of shares. So also the power to investigate. So chapter 14 of the Companies Act 2013 instills upon the tribunal the powers of investigation. The tribunal can authorize an investigation into the affairs of any company if or when an application is filed against the company by 100 members. So 100 members minimum requirement is there. File an application that the company is doing some malpractice, or an investigation is required in the company's affairs. The investigation can be extended to the ownership of the companies. Even the ownership of the companies can go under scrutiny in this case. If a person outside the company is able to provide conditions, even outsider members or person has to provide condition acceptable to NCLT, the latter holds power to authorize an investigation. The court can, in course of action, freeze company assets under given conditions and place restrictions orders on securities. Okay, I'll just give you an example. This might be irrelevant, but again, when you study company law and you refer to company frauds, you can watch this web series at Hotstar, I guess. Arya, Shushmita Sen is one of the leading roles in this, and Chandrachud. So they have this company, a pharmaceutical company, and how the accounts are freezed there when they see that there is illegal. This was a pharmaceutical company, but the amount of opium in the drugs were a lot there. So how the total the company was suddenly it crumbled down, and all its accounts were freeze. So if you see this kind of web series, you get to know what this power to investigate talks about, and how the police is in it, and narcotics department is involved in it, and how they scan the company's image and everything. So if you see that web series, I think this particular point will be more clear to you. So this can go ahead and see that. It's also an entertainment, but also you get to understand the points when you see that. So next is slide 10, where we'll be talking about conversion of public company to private company. So the tribunal, in accordance with section 13 to section 18 of Companies Act, has a say in the conversion of public companies to private companies. Sometimes it so happens because of malicious reasons, companies want to restrict the members and all. So the NCLT has a say there also. The authority not only includes the consent and confirmation for the conversion, it goes further. Section 459 of the Companies Act 2013 maintains that the NCLT can impose certain terms and restrictions or grant approval along with certain conditions. Next is tribunal convene general meetings. So AGM, or extraordinary general meetings, which is called EOGM, are to be held to revise the opinions of shareholders and provide a general outline of the company workings. These meetings ought to follow procedures provided under Companies Act 2013. If for some extraordinary reasons the AGM or EOGM cannot be held or cannot be called, the tribunal, under the provisions of section 97 and 98, is empowered to convene this kind of general meeting, so AGM or EOGM. Financial year NCLT exercises power to change the financial year of companies registered in India. Under section 2 subsection 41 of the companies in the existence should have a uniform financial year on 31st of March. So here what it means is we already know that there is a fixed financial year under Companies Act 2013, but NCLT also has a power to change. Important cases by NCLT in recent times, that is the PNB fraud case, and we have seen NCLT's role in there, which will also be talking on the next chapter, that is corporate scams, where we'll be talking about PNB scam. So I'll discuss that in a deeper approach. In slide 11, we'll be talking about CBI, so Central Bureau of Investigation. Now CBI owes its origin to the Special Police Establishment or SPE, which was set up in 1941 by the Government of India. The main purpose of the SPE at that point were to investigate instances of bribery and corruptions in transactions with the War and Supply Department of India amid World War II. Even after the end of the war, the requirement for a central government agency to examine instances of bribery and corruption by central government workers was felt. The Delhi Special Police Establishment Act was brought into constraint force in 1946. The DSPE acquired its well-known current name. The DSPE was the older version of CBI. So the DSP acquired its well-known current name, that is Central Bureau of Investigation. At first, the offences that were notified by the central government related just to corruption by central government servants were taken into purview. In due time, with the setting up of a substantial number of public sector undertakings, PSUs, the employees of these undertakings were too brought under the CBI domain. So now public sector undertakings employees, if they are involved in any kind of bribery or corruption case, they come under the purview of this CBI, which was previously known as DSPE. That is the Delhi Special Police Establishment. With the nationalization of the commercial banks in 1969, the public sector banks and their workers additionally were brought into the ambit of CBI. So one of the famous case that again we'll be talking in the next chamber, but we can see the involvement of CBI in it, and which is a very good case, I'm sure most of you know, which is a 2G spectrum case. Now we will be coming to SEBI. Now SEBI, in the previous class, also in the live classes, I have discussed what are SEBI's, the legislations like the SEBI Act, or what is SEBI's role. So there are lots of important cases that where we see the involvement of SEBI, that is the Shahara scam, Dinesh Dalmia scam, Satyam scam. So we'll be talking about them in the last chapter. But here we will be just seeing and again refreshing our mind about SEBI, because I have in length discussed about SEBI, which by now you should remember very well. So before SEBI was shaped, breach of regulations was the standard and compliance was an exception. Like before, I am talking about the period of 1980s or before that. A regulatory body was constituted for the sake of SEBI on April 12, 1988 to guarantee the investors' protection and development in the securities market. So when SEBI comes, we see a sea change. And the main objective of SEBI Act was this, that to guarantee the investors' protection and development in the securities market. So this was even the objective of the SEBI Act. The idea of corporate governance initiated by the SEBI relies on transparency, integrity and accountability of management, which likewise incorporates the non-executive directors. If you remember, SEBI's role would only come when a company goes for IPO, or there is subsequent trading of a company's share in the secondary market. So there comes the SEBI role, the role of SEBI, which I had again talked in my previous slides and even in the live classes. So So the main aim of corporate governance is to deal with corporate frauds and scandals, and a system of making directors responsible, that is a key KMP, that is a key managerial person responsible to shareholders for the effective management of the organization, and furthermore adequate concern for ethics and value. So this is all about SEBI, and in the legislation portion also I have dealt with the SEBI Act and a lot more, the powers and functions and everything. We come to the last portion of our regulatory body, that is the Enforcement Directorate, and some of the famous cases in case of Enforcement Directorate were the Jagdish Bhola drug racket case, Malia case, Nirav Modi case. So this Nirav Modi case, I think, and this ED has done a great job in it till now. So we'll also be seeing the subsequent developments of the case. So ED, or the Enforcement Directorate, is an investigation agency, and it investigates cases related to finance, that is economic frauds basically. ED is a portion of the Revenue Department of Finance Ministry. ED deals with two laws basically, as I had said earlier, PMLA, that is Prevention of Money Laundering Act, or FEMA, Foreign Exchange Management Act. ED works for enforcing the provisions for the above mentioned acts. ED has its own kind of courts for trial, that's the special courts, and its own appellate tribunal as well. ED investigates and files suits against those in courts who violates the rules thereunder mentioned in the FEMA and PMLA. It revolves around resolving the matters by adjudication. It works to achieve the objects of both the acts, that is the FEMA Act and PMLA Act. The powers and functions of the ED: to examine the issue, search and place, or search any place, or confiscate any property obtained from laundered cash, that is illegal money. They buy this houses and everything with illegal money and all. Again, if you refer to the web series that I had talked earlier, Arya, you will know how this thing works. Arrest any individual identified with such wrongdoing and file suit against accused individuals. So with this we come to an end with the regulatory mechanism. It's chapter 4 part 2. In the next chapter we'll be talking about the scams. So till then, stay safe, be healthy. Thank you, students.